It is 12:15. Thanks very much. Welcome to the webinar. My name is Mark Maloney. I'm the CEO of VenOps. My other guest today will be Roger Schindel. He is CEO of Karosh Compliance. Roger is a veteran of the healthcare, information security, and risk analysis world, and has served on various boards for HIMA, HIMSS, and has authored works on HIPAA and other critical compliance areas. Today, Indie Practice, which is a platform designed to help independent medical practices, will be presenting Reputation Protection 101 and HIPAA and OIG compliance made easy. I'll be discussing the reputation compression component, and then I'll be handing it over to Roger for HIPAA and OIG compliance made easy. Our sponsors are the Medical Association of Georgia and VenOps and Karosh Compliance. So for everybody on the call who is in any way associated with the practice of medicine or is a provider or part of that organization, write this down. And the word is Indie Protect. And I'll spell I-N-D-E for Indie, Protect, P-R-O-T-E-C-T. And what that is a code that will enable you to go to the VenOps website and sign up for a free trial for 90 days. To give you an idea of see how easy exclusion screening is for your practice when using VenOps. And the word Indie Protect is part of the 3 pillars of support that Indie Practice hopes to provide for independent medical practices. And they are ways to create revenue, the ways to save revenue, and the way to protect your practice. So I'm going to share my screen, and I'm going to go over some Indie Practice items here. And let's see here. It always takes a little bit of fumbling here to see how that works. So Reputation Protection 101, okay, is done through a software as a service program that we provide that is called mydocaware.com. And there are, let's scroll to the top here real quick. The logo says DocAware, and it begins and ends with awareness. The program is designed to do 3 things. And those 3 things are protect your reputation by avoiding an accidental listing on the OIG exclusion list. And I'll go back over that in a minute. An accidental inaccuracy or an inaccurate report on the Open Payments Oversight program, and giving you plenty of warning that all of your medical licenses are unexpired or will not expire. So the three components of which first is the OIG exclusion screening, and let me explain what that is to those that may not be as familiar with it as they could be. Every federal agency has an Office of the Inspector General. The OIG of Health and Human Services publishes a list every month, and it's called List of Excluded Individuals and Entities. Other federal agencies publish similar lists, and every state publishes a list. And on this list are people that have gotten sideways with government insurance like Medicare, Medicaid, or TRICARE. And when I say gotten sideways, I mean they've been indicted or convicted. And these are people that you cannot do business with. Doing business with those individuals will incur automatically civil monetary penalties for your practice. You just want to avoid it at any cost. So we make sure that your name or anything that sounds like your name is not on that list. And if it is, we give you an alert. That's part of what MyDocAware does. The next part is called the Open Payments Oversight Program, and this comes from the Sunshine Law, which requires the medical device industry and the pharmaceutical industry to report what they've paid to providers. And that's literally any payment. That could be a dinner, that could be an honorarium, a consulting fee, a royalty, literally any form of monetary support, including like clinical study support. Even assuming that everything is on the up and up, which it usually is, these mistakes do occur, and we allow you the opportunity to make sure that the reports are. So the third part of a reputation protection service may seem pretty fundamental, but every year the State Medical Society gets a few phone calls in which the medical licenses of the member has expired. And before you say that could never happen, just think about driver's license, passports, other types of valuable licenses that accidentally get expired because somebody forgot to check, or maybe somebody in the administrative side whom you depend on, maybe there was a glitch in the system, and before you know it, you've got a expiration and the train totally stops right there. What we do with MyDocAware is that we start giving you warnings at 90, 60, 30 days out. And if in 30 days you haven't responded, it goes to a text and or a phone call. So we make sure that that does not expire. So let me go back here to the control. There we go. And hand the control over to Roger. Let me stop this screening and let Roger share his control. Here we go. Roger, give me a second to give you the panel here. Okay. Stop sharing that. Okay. And let's see here. Okay, Roger, it took me a minute, but please, you now have control of the screen.
Great. Thank you, Mark. You can see my screen now.
I see your screen loud and clear.
Very good. Okay. So I'm going to take over now. We're going to talk about reputational harm and HIPAA. So get started with, I'm going to talk very briefly about a little bit more about myself. We're going to talk about the 21st Century Cures Act, what kind of privacy and security regulations are coming down the pike, talk about some recent breaches, show you what happens during an investigation when you're being investigated by a regulatory agency, and address areas you need to achieve compliance, and talk about why this matters to you. So, a bit about me, as Mark mentioned, I've been in healthcare and compliance for years upon years. I've worked both at the federal and state level. Worked in technology services as an advisor, as a principal, and we've been doing HIPAA compliance for the last 15 years. I speak at HIMSS and AHIMA, and I contribute to a number of national journals. This is a sample of the kind of clients that we have. So we're all across the spectrum of covered entities and business associates. So let's talk about HHS and access to patient data. The first thing you need to know is the 21st Century Cures Act. HHS, Human Health Services, identified a systemic problem with the recent release of PHI, which was addressed in the 21st Century Cures Act, was passed in 2016 and implemented a year ago, October 2022. And since it was implemented, HHS actually is up to about 70 covered entities, but the first 40 covered entities that were fined in 2023 were for non-compliance with the 21st Century Cures Act. Median fine and penalty was $65,000. While significant, I'll show you why that really shouldn't matter to you as much as some other things. So your obligations under the Act is that your EHR EMR system complies with the Act, that they're using appropriate transaction sets. While you're not responsible for what they do, you are responsible for vetting your vendor to make sure they are complying with the Act. And more importantly to you, it changed the time frame by which you need to provide patients with their healthcare records from 30 days to 15 days, which is why we've seen these fines and penalties come down the road. So here's some examples of fines under the 21st Century Cures Act for not providing records when needed. And just so that we remember, this isn't the only thing you need to worry about. You can see that New England Dermatology PC did not dispose of their PHI appropriately and ended up with $300,000 fine. So next thing you need to worry about is using metadata, the Pixel tools that are being embedded into websites to track people who are accessing those sites. Meta, or Google, was just fined for having over 600 hospitals who were gathering information using the Meta Pixel tool inappropriately, and that is now a class action suit that is going on. Other inappropriate tracking, we can see what happens is the Meta Pixel tool is put on the websites, and again, information is being gathered for marketing purposes in violation of the HIPAA requirements. This is the kind of information that is being gathered and being inappropriately shared without the permission of the patient. So if you've had someone who has developed a website for you, you want to make sure that either you've gotten consent from all your patients to track this information or turn the tracking pixels off. Because fines and penalties, while limited at the federal level under HIPAA are $1.5 million, fines at the state level are unlimited. And in class action suits going on now, the value of a breached record, inappropriately disclosed record, is $3,000. So it doesn't take long to get up to major dollar amounts. Here's some other things you need to worry about. This one is for GoodRx, who was fined $1.5 million for sharing personal data for advertising purposes. Again, the same kind of thing using the Pixel tools. Okay. And then also one of the things you need to make sure of is you're not misrepresenting your compliance with HIPAA. In this case, they displayed a seal at the bottom of their service saying they were in compliance when in fact they weren't. That costs $1.5 million. Coming wave, what we have coming down the pike on top of those things I just showed you is GDPR, General Data Protection Requirements. Over 22 states have implemented some form of GDPR and is being discussed at the federal level. You can think of GDPR as HIPAA on steroids that will expand beyond just your protected health information into protected personal information with some things that are requirements that are much more stringent than HIPAA. So you need to make sure that you're prepared for those. Other regulatory changes that are coming, 2021, the Safe Harbor Law was passed. There were systemic changes to the privacy rules. Congress released a draft of the American Data Protection and Privacy Act which is GDPR. They passed the CISA Act. A new cybersecurity agency was formed. DHS will track strictly your cyber compliance and hold you accountable for that. SEC has always regulated websites and portals, and there is legislation to modernize the health and privacy laws, including the proposed establishment of a new agency similar to the Consumer Financial Protection Bureau, which will be partially funded by the fines that they collect. And as of February 27th, HHS has announced the creation of this new division. So now HHS has had a rap of not being engaged fully in compliance. And so now they've created a new division, which is to do everything compliance related under HIPAA that is being partially funded by fines and penalties that are collected. So why does any of this matter to you? So what do your patients think about their privacy and security? So in the last 10 years, 70% of Americans were impacted by a healthcare breach. 50% of those suffered some kind of embarrassment or financial harm. Almost 60% say they're concerned about privacy protections that you're providing to your patients. Almost 70% say they don't trust your efforts. And 2/3 say that they will change providers if they find their PHI is not adequately protected. I'm going to show you here in a minute, lost business actually represents the largest cost to your practice from a breach. So here's an example of what you can expect in terms of cost to your practice outside of fines and penalties. And to make this calculation, I use the median size of a fine from OCR right now, which is $65,000. And you can see your largest fine is from lost business, which amounts to 47%, almost 48% of the cost, which in this example is $218,000 of the approximate $330,000 it's going to cost you for having a breach outside of any fines or penalties that are assessed. So you should be worried mostly about your loss of reputation, reputational harm, and lost business. Clients that leave your practice, clients that you never see because of your referral business, and with reputation having been harmed, you won't get those referrals. So you want to make sure that you are looking at this. Stats are that every practice, 96% will have at least one breach every 24 months, and almost half will have 5 or more breaches in that time period. So one breach is $65,000 is again the costing you almost 400 grand when you think about the add-on expenses from lost business and loss of reputation. So the nightmare scenario for you is what happens if you have a breach. This is an example from one of our clients, what OCR asks for in a breach investigation. So forensic reports, risk assessments, remediation plans, policies and procedures, training reports, etc. And if it's 500 more records, you need to actually notify the media of your breach. And so we have what we call the circle of compliance, 5 key things that you need to achieve for success. So you need to conduct your risk assessments, create your remediation plans, that's both security and privacy, correct any deficiencies. You have an internal management audit program. You need to be able to demonstrate you're actually operating the way you say you are, your policies, procedures, and safeguards, and you need to have a robust training program. We go through those very quickly. The risk assessment is actually a multi-factor, multi-variable assessment of probabilities. So anybody that you're using to help you do your risk assessments needs to understand what these probabilities are because they change over time, and should have that embedded in whatever tool they're using to do your risk assessments. By the way, there's 103 vulnerabilities you need to do this for. Only about 20% of those are technology, so the other 80% are people and processes. So you really don't want to just rely on your IT vendor to be doing your risk assessments and remediation plans. This is a sample of a remediation plan. What's important to note is that you have a target date as to when you're going to remediate these items, because the regulatory agencies understand you can't remediate everything at one time, but they want you to be able to show meaningful progress through that remediation. Required policies and procedures we run into all the time. People have a couple policies they've shoehorned into their employee manual, when actually your policy and procedure manual is going to run you somewhere around 300 pages if you have all the policies that are required. So you want to make sure that you have all the policies you need to comply with the regulations. Internal audit program, again, needs to be done so that you can demonstrate that you are operating the way you say you do. The way we constructed our audit program, we kill 4 birds with 1 stone. We update your risk assessments, your remediation plan, your policies, procedures, safeguards, and do the audit all at one time. So a very efficient way to go about doing that. Training is a requirement. One of the items that OCR and actually Homeland Security has indicated that inadequate training is the root cause of virtually every breach, because you're required to train on your own policies and procedures. Generalized HIPAA training won't get you where you need to go. This is a list of the things that you need to have in your training logs: who was trained, when they were trained, who did the training, a copy of the training, and you need to maintain all that documentation along with everything else around HIPAA for the last 6 years. So if you're going to work with an outside consultant, or if you're going to work with, you have someone in-house, these are the preferred vendors of training and certification to make sure you're working with someone who can actually keep you compliant, has the background and knowledge to handle all the things I talked about previously. HIPAA is one of the legs of the stool around compliance, as is the OIG exception screening. And that's all I have to say. You can contact us at Caroche.com. Here's my email address, or you can call us at 219-230-9000. You actually will get a email from us with a certificate for this training and a way to contact us, and a number of ways we can help you make sure that you're covering this one leg of the stool regarding compliance. And with that, Mark, I will turn control back to you.
Very nice. That I thought was well done. Let's see here if I can turn that off a little bit. Show my screen now. Good. I got a couple of texts while you were talking, asking a couple of questions. One was, can I get a copy of the recording? And everybody who registered will be offered a link to the recording. That's one question. Somebody asked how they sign up for MyDocAware, and all you have to do is go to the website and click register. The cost for MyDocAware as a standalone service for one doctor is $15 a month. And let's see, Roger, you have a program called HIPAA Express.
Yeah, so HIPAA Express is our 2-day workshop. Practice comes into the workshop, and in 2 days, we will get you a compliant program around HIPAA, go through everything you need to have in place, and actually put it in place with you during those 2 days. Subsequent to 2 days, we have a 6-week, 1-hour-a-week cycle where we go through every policy and procedure you need to have for your HIPAA compliance program. And we guarantee our work. You come to the workshop, you don't like what we're doing, you don't think it has value, we return your money. If you do go through the workshop and you go through the customization, your policies and procedures, and you do a few things that your IT people need to do, and we will guarantee your compliance. In fact, indemnify you for the first $100,000 of any fines and penalties that are assessed at the federal level. So We've been doing this for a number of years and decided we needed to come up with a way to help independent practices become compliant. So we brushed off HIPAA Express. We've had great success with it. People love it. And again, the cost of it is $3,500, but going through it, if you don't like it, we return that money. And we will guarantee the results by indemnifying you from fines and penalties. When we send out the email, we'll send you a link where you can find more information about how to either talk to us about the HIPAA Express or to sign up. We do them both in person around the country, and we do them on a virtual basis with a WebEx like this.
Well, hopefully in today's webinar, we've talked a little bit and made reputation protection for providers and medical practices a little bit easier to understand. Also, we've talked a little bit about compliance, whether it be OIG exclusion screening, which is a mandatory form of compliance from the Health and Human Services OIG. And by the way, that falls under the Social Security Act and the Federal False Claims Act, so those are federal laws that govern that. And Roger has laid out a really clear program on how to make HIPAA compliance a little bit easier for your practice. If you have any questions, please, you can email me at mmaloney@venops, and Roger gave you his. And like I said, there'll be a link to the recording available. I don't see any other questions in the chat, so I wish everybody a good Wednesday. And Roger, thanks very much for participating today.
Thank you, Mark.